Hello, my name is Devan Gallagher, and I am introducing this paper written with Elizabeth Barnert, Laura Abrams, and Haoyi Lee, applying a health development lens to Canada's youth justice minimum age law. We applied a life course health development framework to examine experts' views on Canada's youth justice minimum age law of 12, which excludes children age 11 and under from the youth justice system. Youth justice minimum age laws are an important protection for children, yet statutes vary widely across the globe. In contrast to the United States, in 1984, Canada enacted the Young Offenders Act, which excluded all children 11 and under from the youth justice system. With the passing of this law, children between the ages of 7 and 12 no longer fell under the jurisdiction or responsibility of the criminal legal system. In 2003, Canada's Youth Criminal Justice Act replaced the initial legislation, but it maintained the previous minimum age threshold. The 2003 legislation implemented a holistic, non-punitive approach to youth justice by addressing circumstances underlying offending behaviors, directing resources toward rehabilitation, and ensuring meaningful consequences and support for adolescents. So far, researchers have not applied a child development lens to understand Canada's minimum age law or its holistic approach to child well-being. Our objective in this paper was to use the life course health development framework to examine the extent to which Canada's minimum age law policy conforms to key principles and concepts of child development. We interviewed 21 experts across Canada to understand their views on Canada's youth justice minimum age of 12. The 7 principles of LCHD model health development, unfolding, complexity, timing, plasticity, thriving, harmony, were used as a guiding framework for qualitative data analysis in order to understand the extent to which Canada's approach aligns with developmental science. Although the LCHD framework was not directly discussed in the interviews, the 7 LCHD framework concepts emerged in the analyses and correlated with 7 justice principles, which we refer to as LCHD child justice principles. We found when we applied these principles as a response across a child's life trajectory, it led to an ability to understand and recognize the root issues behind a child's disruptive behavior. Interviewees explained that with appropriate intervention tactics, children in distress or with unmet needs could find support outside the justice system and ultimately lead healthy lives. For example, one elementary school principal said, "If we're going to change behavior for a child, punitiveness doesn't work. Punishment doesn't deter a child from changing, but actually addressing the skills that are missing or providing the necessary support. That's what changed kids." This directly aligns with the LCHD Harmony framework. Overall, child involvement in the youth justice system was considered to be developmentally inappropriate, with alternative systems and approaches regarded as better suited to support children and address root causes of disruptive behaviors, so that all children could reach their potential and thrive. Limitations of this paper include that Canada does not explicitly legislate its minimum age law with reference to LCHD principles. Our interviews did not directly ask about the LCHD framework. And Canada is an extremely diverse nation, and so there may be some provincial variation that exists and was not captured in all interviews. Canada's approach to its minimum age law aligns with the LCHD framework, indicating that Canada's approach adheres to concepts of developmental science. Intentionally applying LCHD-based interventions may be useful in reducing law enforcement contact of adolescents in Canada and of children and adolescents in the United States, which currently lacks a minimum age law.